U.S. immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. And today I have a good topic for you. I'm going to be talking about the VAWA petition process. So, in other words, the process where you can apply without your spouse or relative who is mistreating you. Now, there are different pieces that come together to make a thorough application, a thorough and good, solid application. And so once we determine that our clients qualify, we do have to make sure that I and my team have to make sure that we follow each and every one of those steps, a solid application together. Now, there are specific requirements for a VAWA petition. And if you miss one of those in the application process, you're likely going to get a request for evidence. And if you don't respond to that request for evidence, that's first of all, it delays your application. And then, second of all, if you don't show that you meet that requirement, you will be denied, and it will all be for naught and just adds to your stress. So what we do is when we talk to our clients in a consultation, we evaluate and make sure that our clients can meet each and every one of the requirements. Then when we get to work to start working, and we get to work right away, once a client becomes our client, we get to work to get this done. We take your statement. Your statement is going to be essential evidence. So, the number one question I'll get when I tell people, or I do videos about this, that they can qualify without their spouse, the number one thing I'll get is, but what evidence do I have? I don't have any evidence. Yes, you do. What you have is your memory and what you had to go through with that spouse. That's going to be essential. And even if you have other evidence, even if you have other types of evidence like pictures, if you have police reports, those can also be used. But guess what? You still need to include that statement, because the statement is going to give the officer clear information, chronological information about the ordeal that you went through. Evidence, sometimes it only tells part of the story. So you do want to put things into context for the officer through a declaration, and that is going to be accepted as evidence. So once we work on that declaration, and let me just pause here, because this is so important to your process that I don't want this to sound like an understatement. I don't want you walking away thinking, oh, a statement, I can just write a statement. If you estimate this process and you underestimate the types of evidence that you have to provide, you will you will be denied, right? Now, with your statement, of course, it has to be true and correct, and it is accepted as evidence. And the way that it is drafted is very similar to testimony in court. So you don't want to play around with the truthfulness of this. It has to be truthful, because there are penalties if it is not truthful. There could be potential penalties. But another thing is all the necessary information needs to be in that declaration. Some people, when they try to do it themselves, or they choose the wrong individual to do this, they put this statement together and they miss all the pieces of the puzzle that need to be in this declaration, all the required evidence, all all that you went through, the details of what you went through. Sometimes you have to be so detailed that you want to break down your routines with your spouse, exactly what was said by your spouse, especially when it comes to emotional abuse and or mistreatment. Um, whether or not you lived with your spouse has to be in this declaration. So you're going to want to make sure that you have an attorney that can assist you with it has to be true information but the right information. Because you could talk about the fact that you were in love with your spouse at first, and then you just do a sentence that says, I was in love with my spouse, we met in love, then he or she started to mistreat me. Full stop. Please give me this relief. End of story. That is going to lead to a denial, because not everybody has the expertise or the knowledge to be able to know what to put in there, and to put into the declaration. So it's essential. It is evidence here. It is like testimony. And you accept there's no well, sometimes a request for evidence can be a type of cross examination or examination. But sometimes, if it is not done correctly, you could very well just get a denial without any further questions about your declaration. And then other evidence. We do have to also any credible evidence. So if your statement is the only thing that you have, because remember, being the victim of mistreatment also means that if this spouse or relative had control over you, you may not, and control over your finances, you may not be on the lease. You may not be on the bank account, because this is what spouses and relatives who are mistreating you do. They take away that control from you. And this is why the VAWA process is set this way, so that you provide credible evidence, any credible evidence, because you may not have had kinds of access to resources that you would need to show definitively that you experience mistreatment. You may have, as I said before, your statement, some text messages, those can be submitted as evidence as well. Sometimes there are pictures that you have, maybe pictures of damage to your property, not necessarily injuries to you, that can be accepted as evidence as well. So, and any other evidence. This is where it's also important to have representation through the process, because we have I have sat down with my clients who at first they thought they didn't have any evidence. And by the end of it, because what they thought they didn't have evidence, because they were thinking the same thing that you may be thinking right now. And that's, I don't have pictures, I don't have a police report, but that is not all that counts, right? Even your own family members or witnesses of what happened to you can count here as evidence. So after we put this down, and now another thing is proof of a bona fide marriage. So you'll have to show proof that your marriage was bona fide if you are married, or that you do have an existing relationship that qualifies you. So for example, if you're applying based on mistreatment by a parent, you're going to have to show the parent-child relationship. If you were being mistreated by a spouse, you're going to have to show that first of all, you legally got married, and second of all, that the marriage was bona fide, because they're still concerned about marriage fraud. Bona fide means no, the VAWA, our presentation of these types of applications can differ from marriage-based cases, because the dynamics are different. With the marriage-based situation, the spouses are working as a team. So they are working together to provide joint documents. They are working together to get all the information that need to help to make their case successful. But then when it comes out to the VAWA situation, sometimes the person was deprived of joint documents because of the mistreatment. And so that's where we have to look at other alternative evidence to show bona fides, not necessarily usual, maybe not a joint account, maybe it has to be witness statements talking about the fact that they knew of the marriage and that it was bona fide. So that could be one thing. And other types. So for example, you may not be on the lease, but are there other ways to show that you share the same address? For instance, did you have important mail coming to the same address? And then do you have pictures of maybe mail coming in that from your spouse with the same address? Or do you have other, not necessarily important, like official documents with both of your names on it, but do you have other types of mail with both of your names on it? Um, so those are examples of ways that we do have to brainstorm about other types of evidence that can show the bona fides of the marriage, especially in those cases where you were not able to have the joint documents because your spouse, that was a part of the whole control tactic of the spouse, is to take that away from you, the ability to have joint access to money and so forth. So once we put all of that, no, here's another requirement that is overlooked by many, and that's the showing you have good moral character. So our approach is going to be different just based on what the situation is. If our client does not have a criminal record, we do that by getting the background check done for our clients to present to the immigration to show a clean background check. And that usually is enough to show then that our client has good moral character. But then, if our client does have some things in their history that can potentially reflect negatively on their good moral character, we have to evaluate what is necessary to prove on, convince the officers that despite this happening, they do still have good moral character. Another thing is you have to go backwards 3 years. So you have to show that you've had good moral character in the past 3 years. So it's not necessarily forever into the background, but at least in the most recent 3 years before you apply, you do have to show that you have good moral character. Now, once we submit everything, we put it together. And of course, I put my legal statement at the top to make sure. And in each case, I talk about the specific situation. So I make the legal arguments to support your case. That's also important because it can provide the officer, especially when the officer doesn't have a lot of context, the legal letter can do that. So the attorney offer letter can do that. So it puts the case together for the officer. Of course, the officer has to make their own determination, but this can be very helpful to them when they're going through the facts and they have to understand the big picture here. That can assist. Especially when there are different pieces and the case is complicated. It is essential in this application. Now, once this is done and everything is filed, then the process starts. Now, it's about a 2.5 to 3 year process total from beginning to the green card. At around the 9-month to the 12-month mark, you would be able to get your work permit and your travel document. So it does take some time before you see the payoff. And they are now assigning multiple service centers to process these cases. So hopefully we see it go back to being 6 months because processing time was shorter, but it has gotten very long and it's backed up. Once it's in, though, you'll be scheduled your biometrics appointment about 2 months after everything is filed. And then after that is the wait for the prima facie determination letter. That's coming in about 6 months or so. You get the 3 to 6 months, you get the prima facie determination letter. The prima facie determination letter is the letter that says, based on everything they've reviewed, they don't need anything else and they believe you qualify, but they need to do a more detailed review. They're saying that with this letter, go ahead and seek whatever assistance the state will allow you to receive. So in certain states, you are allowed to get additional benefits. You may be able to get your driver's license. You may be able to get certain public benefits like food assistance, housing assistance, medical assistance. And so you get these benefits, you get an approval. So this prima facie letter is issued every 6 months. It's really, in the past, it would be issued one time and then you'd get the approval, but the system is backed up right now. So you will get that prima facie until they speed up the processing times. You will get that prima facie determination letter every few months. So every 6 months or so, you'll get this updated, renewed prima facie determination letter until you can get the final decision. Now, the prima facie determination letter is definitely a good sign that your case is going in the right direction. Does not mean that you don't have hurdles to go through in the future. So you should always still, keep up to date on your case and make sure that if you're still experiencing mistreatment, that you continue to document this because they may have additional questions. For example, if they look at the details of your petition, maybe they see you haven't been separated yet and they have additional questions about that. Keep in mind, it's not required for you to be separated to apply for this, but there are certain things that they may want to check up on before they issue a decision. So always continue to document the mistreatment or any changes or any escalation in what you're experiencing in case immigration continues to have questions about what you're going through. And then at around the 2.5, so 2.5 years after it's filed, you could get the VAWA decision. And let's hope that they're going to speed up the process to less than 2 years. But the VAWA, no, the approval of VAWA means that you will now be put into a deferred action status, where you will be protected and you'll be able to get a new work permit automatically if it's stated in your application that you want the work permit issued right away. You do that. It's as long as you've already applied for adjustment of status, it's going to move on to the adjustment of status process for you to either get the permanent residence in the mail if the interview is waived, or to attend the interview. Now, at the interview, it is a part of the policy that they are not going to go into the details of the mistreatment because when you got the VAWA, they already made a decision on that. At the point that you're doing adjustment of status, they're now looking at your background, making sure that everything lines up for you to get the permanent residence. For example, that you don't have any new criminal convictions or past criminal convictions that render you inadmissible, that you don't have any past immigration violations. Keep in mind, past immigration violations, they will not count an overstay against you. They will not count working without a permit against you. They will not count crossing the border without permission against you unless you did it repeatedly and it leads to a permanent bar. But even in cases where you do have those issues, maybe you've had a past criminal issue, maybe you've had past serious immigration violation that could stop you from getting the green card, there is also the waiver process. The waiver process allows us to also apply for forgiveness for whatever issues may come up that do put you in danger of being denied. So that in a nutshell is how we approach the VAWA process. It is not a process that you should be doing on your own. And unfortunately, I've seen people that come to me after the fact trying to do it on their own and they get lost, especially when immigration has very detailed legal questions that they can't answer. And sometimes the questions are so intimidating that they cower and they don't move forward with the process because they just believe, oh, maybe I don't qualify anymore, right? So you want to make sure that if you're going to invest in your future, that you also do it right so that you don't come upon a bump and you're unable to go over the bump because you don't know how to proceed. It is a complex process that has different pieces to it, different parts, and I do have an entire team. So even though I come on these lives and talk to you about the work that I do. I am backed by an entire team of people that assist me to get this done, to achieve this good work. All right, so thanks, everyone. Now, what I'm going to do is I'm going to answer your questions, and then I'm going to have to head out to the next appointment. So let's go ahead. I'm answering questions now. So put those questions in quickly so I can answer. Hi there, NM. It's nice to see you. Hi, Cassiana. It's nice to see you. Okay, so for VAWA, you've received your acknowledgement letter. So I'm thinking this is the receipt notice. We call it receipt notice, where when you have sent in the VAWA petition, you will get your receipt notice. What comes after that? It's going to be the biometrics appointment that comes after that. My friend filed for citizenship, but she don't know her husband's ex-wife date of birth to fill in the form, and her husband is not telling. Would that be a problem? They may have a number of issues here. If they are filing for citizenship based on being married to a US citizen, and that citizen is not cooperating with them, it raises a question in my head as to whether they can even proceed with the citizenship. Now, if it's been more than 5 years since they've had citizenship and the spouse is not disclosing anything about the ex-spouse, it may not affect the citizenship process. But then again, that can open up a can of worms, right? Because why isn't the spouse trying to this, why are they hesitant to give this information? Is it that they were married at the same time, or that there is some other facts that could be raised that could potentially even shed light on your permanent residence to begin with? This is why immigration asks for this kind of information, because they want to know that if you're applying for citizenship, if you got permanent residence, they are going to go backwards into the background to make sure that there are no facts in your background that will disqualify you from getting citizenship. And if this fact about the ex-wife then opens up a can of worms about something in the past that could affect your permanent residence, that's going to be where the problem lies. So I would say tell your friend to talk to me, and we can talk about it. I can figure out what's going on in that situation to properly advise them. And this is where the consultations are very important. It's because when it comes on to complex scenarios like this, we need to talk. And sometimes it even takes more time than a consultation to get to the bottom of the question, because there may be, we need to do research, maybe we need to pull records to see what's going on with that. So they need to have an appointment, definitely, because I've seen people get denied for issues like this. So I had a case recently where she was denied years ago, and she was on the brink of being charged with immigration marriage fraud, and she was denied citizenship because when she was applying, her spouse, who was living in the same house with her, who secretly divorced her. She didn't know that they were divorced. He secretly divorced her, and she went ahead, submitted the citizenship application, saying she was married to her spouse. And they were looking at it, questioning her about why is she saying she's married when they knew she was divorced, right? So she didn't qualify for the citizenship then. Then years later, we were able to go in and straighten this out later on, but they suspected her of wrongdoing because she was disclosing she's married, and this man secretly divorced her. So they were taking it that she was lying to get citizenship. So years later, we're able to straighten it out, and she did get her citizenship. So we're happy about that. But this is where representation matters as well, because she could not understand up until she spoke to me what happened there. Um, if someone used advance parole to travel, when they come back to the US, are they admitted or paroled? So it's going to say paroled. But it's now yeah, it's going to, chances are sometimes what they do is put paroled, which is fine. Being paroled does still qualify you for the adjustment of status process as well. So filed VAWA, received on 12/27/22, got everything but work permit and advanced parole category. How long does it take? So it could take up to a year. Um, you're welcome. All right, so I'm coming on here. I'm answering questions on Instagram now. What if you missed notice to appear? How could you get the case to reopen? So you'd have to go back to the court and you'd have to show that the reason for you not being able to make the court case, and then have it reopened based on that. But you want to make sure you have representation there. So give us a call. We definitely do deportation defense, and we can look at what happened in your case. How can you change status to a out of status? So you'd have to apply for it before you overstay. So if you have 6 months in the country, you just have to make sure that you file for your application before. But keep in mind that if you're married to a citizen, you're the son or daughter of a citizen, and you're under 21, or you're the parent of a citizen who's age 21 or older, being out of status is not going to affect your case unless you overstayed with certain types of visas. You don't want to overstay with like the crewman's visa, and you don't ever want to overstay with a K1 and then leave that fiance and go marry somebody else, because you will not be able to adjust status there. So there are certain visas that do bar you from doing adjustment of status that you have to be careful about. Now, and if you're the spouse of a permanent resident, that's where you definitely don't want to end up overstaying your time before applying. Now, being the spouse of a permanent resident, you have to apply before your time expires, and your priority date has to be current. So you have to check on those two very important details when you're thinking of applying for this. Question: do we need COVID vaccine for someone coming to the USA on the K1 visa? So you're still going to have to do your medical, and the medical does require you to do the COVID vaccine. If you file for sister, how long does it take? 14 years. So if you have more questions, this is where it's important to schedule that appointment. How long does it take to put the papers together? So it depends on how. Now, I usually say this: the time it takes for me to submit the petitions is going to depend on how quickly my clients work. We work very quickly. We prioritize our clients and we get things moving very quickly. Um, but we also depend on our clients to do the same thing. So we can get it done within a matter of a few weeks, as long as our clients are giving us everything that we need to get it done. How long is the waiting period for the green card through marriage? So anywhere from 5 months to a little over a year. How will I know when USCIS received my RFE medical for my VAWA case? Sometimes they'll state it on the website. They will provide the update saying they've received a response to the request for evidence. And they don't need anything further. But sometimes if it's the service center, so if you've gotten to the point where you're at the field office, right? And the field office is now making a determination about whether they're going to issue the green card, they sometimes don't update it, which can be nerve wracking. But That's something that happens. After 3 years of marriage, never filed any papers to immigration. I got divorced peacefully, no cosmetic, no violence, no VAWA. Can I apply for the green card? I can't say you can't apply for the green card. This is where I do consultations. Now, if there was absolutely no movement, then VAWA is not going to be there has to be a form of mistreatment, like emotional, mental, there has to, even financial abuse to qualify for this. So if I got married to a citizen last week, can I go back to Jamaica and return before I start filing paperwork? Or once I get married, I have to start right away and be stuck in the US? This is where it's important to talk through your issues, because it's going to depend on what your particular circumstances are. If you do have the means to travel, you can do that, but keep in mind that when you're coming back on that visa, you cannot be walking through the airport with the intention of coming back to file papers, because that's going to get you, you're going to be turned around and sent back to Jamaica, and they're going to tell you, now you really have a problem. So you want to make sure you schedule an appointment with a professional, and this is where I help my clients to talk through your circumstances so I can understand exactly the solution here. Should a green card holder apply for citizenship before marrying his or her spouse who overstayed their visa? Chances are that's going to be required here, because if your spouse already overstayed, you're not going to be able to help them to apply for adjustment of status until you're a citizen. All right, this is going to be it for me today. I'm going to be back tomorrow to, talk about a different issue and then also address your questions again. So if you want to get in touch, you want to schedule that appointment, I suggest you do that because my schedule is filling up. Go to the link in the profile, link in the description of the video on YouTube, Facebook, and Twitch. And then on Instagram, it's in the link in the profile. Click on that and you'll be able to access the link that's going to be able to get you to the website, get you to the link where you can schedule your own appointment without calling. But if you do need help, go ahead and call the office, and staff will be more than happy to assist you with that. Have a good day. I will see you tomorrow. Have a good one. And you're welcome, Marcelo. Have a good one. Bye bye.